Good evening, everyone, and thank you for joining us for today's masterclass titled Robojudges and Legal Bots AI at the Crossroads of Justice and Regulation, organized by Sai University School of AI. It is a great privilege to introduce today's esteemed speaker, Dr. Mohamed Chawki, a globally recognized authority in cybercrime, cybersecurity, victimology, and digital law. Dr. Chawki is a professor of criminal law and cybercrime at Naif Arab University for Security Sciences in Riyadh, Saudi Arabia. With over 25 years in judicial service and 18 plus years in academia, his career represents a rare blend of courtroom experience, academic excellence, and global impact. He earned his PhD from the University of Lyon 3 in France and later achieved the prestigious HDR, which is Habilitation et de Rigueur des Recherches from Aix-Marseille University, the highest European qualification for professorship. Dr. Chawki has taught at renowned institutions such as Aix-Marseille University, University of Paris, and the German University in Cairo, delivering lectures in both English and French across 17 plus subjects, including cybercrime, digital forensics, and comparative criminal law. He is the founder and chairman of the International Association of Cybercrime Prevention, AILCC, in Paris, and the co-founder of the African Center for Cyber Law and Cybercrime Prevention, established in collaboration with the United Nations and hosted at Nelson Mandela University in South Africa. His scholarly impact includes 10 authored books, 35 peer-reviewed papers, and over 250 presentations worldwide. His contributions to the field have earned him prestigious global honors, including national medals from Egypt, Brazil, and Canada, and the Award for Excellence in Scientific Research from Naif Arab University in 2023 and 24. Beyond academia, he has served as editor-in-chief of the Arab Journal for Security Studies and as a board member of the Cybercrime Division of the American Society of Criminology, actively shaping thought leadership in cyber law. Fluent in multiple languages and decorated with more than 25 awards for academic excellence, Dr. Chawki continues to bridge the worlds of law, technology, and public policy, offering deep insight into how we navigate cyber threats in an increasingly digital world. Please join me in warmly welcoming our speaker, Dr. Mohamed Chawki. Welcome, sir, and over to you. Sir, I think you are on mute.
Thank you so much. Good evening, esteemed colleagues and guests. I am delighted to participate in this masterclass on robo-judges and legal bots. That's in fact one of the hot topics in 2025. I would like first of all to thank Professor Ajith Abraham and Sai University for their invitation. In fact, I know Professor Abraham since now 20 years, and he invited me several times to India to deliver guest lectures. We have co-edited some books on cybercrime with Springer. Our latest book on cybercrime was released last year by Springer. We have also co-organized several conferences on cybercrime together in previous years. This year, we are working together on the establishment of an international center of excellence in AI and law that will be hosted by Sai University. In the upcoming months, we'll provide you with more information. So now let's start my presentation and let me share my slides. So our topic, robo-judges and legal bots, may sound innovative, but in truth, it's not a theoretical subject. It's in fact a timely, urgent reality. We are living in a transformative era where artificial intelligence is no longer a theoretical tool. It's actively reshaping how legal decisions are made, how justice is accessed, and how laws are enforced. This presentation addresses the central challenge. How do we resolve innovation with regulation? How do we resolve innovation with regulation? How do we ensure that AI serves society and the rule of law? So let's begin by reflecting on key milestones in the evolution of law and technology. In the 1980s, computers developed legal documentation. The 1990s brought the internet, vastly improving access to legal information. In 2008, e-discovery tools became essential for managing electronic evidence. By 2016, AI had entered legal research and predictive analytics. And last year, in 2024, the European Union introduces for the first time the European Union Act, the European Union AI Act, marking a critical moment in regulating AI's role in justice. AI, in fact, is not merely an assistant, it's a transformative force. It automates the generation of legal documents, reducing human error and accelerating routine processes. Predictive analytics helps lawyers access case outcomes and develop data-driven strategies. AI-powered legal research tools offer real-time access to precedents, previous decisions, legislation, and commentary, improving research accuracy and speed. Virtual legal assistants nowadays engage directly with clients, offering them the support and making legal services more accessible. Together, these tools reduce costs and broaden access, especially for populations traditionally excluded from legal services. So, generally speaking, justice must be accessible to all. Justice, or the accessibility to justice, is a constitutional right. Justice must be accessible to all, not only those who can afford it. Globally, millions worldwide are prevented from their basic right to legal counsel due to geographic, economic, or any linguistic barriers. And here, AI emerges as a force for inclusion. Nowadays, chatbots can explain legal rights in any language, can help individuals contest fines or seek compensation without needing a lawyer. And that's one of the advantages of AI. Platforms like Don't Pay, I don't know whether you know it or not, Don't Pay represent an innovation offering people the ability to file small claims, cancel subscriptions, or challenge parking tickets entirely through AI-powered interfaces. These tools don't just save time, they restore dignity. They empower the average citizen to interact with legal systems that were once closed off. But with such a progress comes complexity. And that's normal with the advancement of new technologies. We must provoke a set of deeply ethical questions. The integration of AI into legal workflows is growing rapidly, but we must ask ourselves, what are the unintended consequences? AI systems can inherit bias from the data they are trained on, leading to discriminatory outcomes, especially in sentencing algorithms or bias assessments. Another important concern is privacy. Privacy is a critical concern. Client-attorney confidentiality must not be breached by AI surveillance or third-party data sharing. Another important question: who is accountable when an AI system gets it wrong? The software developer, the law firm, or the regulator? So we need clear, enforceable frameworks to define ethical AI, and perhaps most importantly, we must foster continuous, inclusive discussions across law, ethics, computer science, and civil society. The European Union Artificial Intelligence Act is the first major attempt by a governmental body to regulate AI at a scale. This legislation, this act, adopts a risk-based approach classifying AI systems into categories from minimal to unacceptable risks. In fact, it recognizes that not all AI poses the same threat. So we have three major categories: high-risk systems, like those used in biometric surveillance or credit scoring. It will be subject to strict obligations, including risk assessment, transparency, and human oversight. The second category, unacceptable risk system, such as social credit scoring, which will be banned outright. Thirdly, we have the very acceptable risk system, and this system doesn't violate human rights. Now, let me give you more details about the three risk categories. First of all, the unacceptable risk includes technologies that manipulate human behavior or exploit vulnerabilities. And these technologies will be considered illegal under European Union law. By the entry into force of this act, which entered into force in August 2024, all European Union countries must regulate and must change their legislations to enforce this act. So the unacceptable risks includes technologies that manipulate human behavior, and they will be considered illegal under the European Union law. The high-risk AI, such as those used in law enforcement and court rooms, they must comply with detailed requirements related to transparency. Then we have a limited risk AI, like customer service bots. We must inform users that they are interacting with a machine. Finally, we have the minimal risk AI, like grammar checking tools. They will remain largely unregulated, and this approach by the European Union for the first time worldwide to regulate the use of AI reflects balancing innovation with individual protection. For legal professionals, the European Union AI Act is not just about regulation. It is about responsibility. And that's a very important point from the legal perspective. We must understand how AI tools we use will fit within the Act's risk framework. Before deploying AI, lawyers must conduct risk assessment to ensure that the systems they are using do not infringe on clients' rights. Documentation is a key. Documentation is a key. It means that we must prove that we comply with transparency, accuracy, and oversight obligations. And we must stay updated as the regulatory landscape evolves, so we must our practices. This is especially vital for those advising corporate clients who may also fall under the AI Act obligations. For legal professionals, this act is not just about regulations, as I mentioned, but it is about responsibility, and we must be updated about any changes so that we may not fall under any obligations. Let's mention a very important point. Firms across the globe are showing what is possible. So, for example, an international law firm, which is Baker McKenzie, has integrated AI into contract review, cutting document analysis time by 60% while maintaining accuracy and legal exactness. And that's one of the advantages of using AI in the legal environments. Also, Alan's development of AI in legal research enables lawyers to examine precedents and draft arguments in record time. These examples illustrate that AI, when ethically and strategically applied, can boost client satisfaction, reduce costs, and deliver faster and more accurate legal services. They also show us that legal profession can evolve without losing its spirit. To sustain this evolution, legal education must change. In fact, AI is not just, as I mentioned at the beginning of my presentation, it is not just a technical tool, it is a legal subject. Accordingly, students today must understand algorithms, bias, data privacy, and mechanics of digital evidence so that they will be updated in all developments in AI. And courses delivered by international universities include the European Union AI Act, data governance, tech ethics, alongside constitutional and civil law, because they are linked to the use of AI. And I think that tomorrow's lawyers must not only think like advocates, but also like data scientists and compliance officers. In fact, AI in the legal profession brings promise, but it also has serious challenges that we must confront with realism and responsibility. Let's begin with one of its strengths, the ability to process vast amounts of data rapidly. As you all know, AI tools can analyze thousands of legal documents, precedents, and court rulings in seconds. And this help lawyers and judges to save time, weeks, or even months. And also, AI tools offer wonderful potential in litigation, contract analysis, and compliance reviews. Yet, despite these advantages, there are critical weaknesses. Legal language is inaccurate and contextual and culturally embedded. Phrases like reasonable doubt, that's one of the phrases that we use in the legal form, reasonable doubt, or due diligence, require interpretation by the machines. In fact, AI systems also rely on heavily and training data. If the data is incomplete, if the data is biased, if the data is out of date, the results can be misleading or even dangerous. So there are some opportunities brought by AI. AI can bridge the legal gap for populations who can't afford traditional legal services, but at the same time, it has some disadvantages that needs more care when using it, and we can't rely on it 100%. Now, let's turn to one of the most pressing topics in AI, ethics. Legal ethics results on support such as confidentiality, fairness, and integrity. The introduction of AI raises new questions in all these areas. First of all, confidentiality. Lawyers handle highly sensitive information, and AI systems particularly host this information on cloud platforms, and this may introduce vulnerabilities. For example, if legal data is stored or processed by a third-party vendors, the client's privacy will be violated. Secondly, informed agreement. Informed agreement, if a lawyer uses an AI tool to prepare a case or to analyze a case, should the client be notified of this use or not? Should clients have the option to opt out of AI-based advice? transparency becomes essential. Thirdly, a very important point, bias in algorithms. Studies have shown that certain AI systems, especially in criminal justice, can reproduce gender bias. Now, let's look at where we are headed. One of the most evident trends is automation. In fact, AI will continue to take over repetitive, rule-based tasks such as contract review, compliance checklists, document formatting, and even early-stage dispute resolutions. And these tasks don't require high-level legal reasoning, but they consume time and resources. So automating them allow lawyers to focus on higher order thinking and gain time to focus on the legal arguments in the courts. Another trend is data analytics. Law firms are beginning to use AI not just to retrieve documents, but to generate insights. And for instance, litigation outcome prediction models can forecast how a specific judge might rule on a case based on thousands of past decisions. AI is also increasingly being used in decision-making support. Rather than replacing human judgment, it offers increased intelligence. Of course, I'm not saying that an AI machine or an AI tool will replace in the upcoming years a judge in rendering a decision, but it helps to increase the intelligence in data gathering and saving the time for judges to render decisions on hundreds of cases each month. A lawyer might consult an AI system to assess legal risks, and of course, relying on their experience, they can advise their clients. But these trends also require us to reimagine legal responsibility. If a lawyer uses an AI system that gives bad advice, who shall be liable? The lawyer, or the software provider, or the AI developer? All of these questions need answer. The European Union is not alone in its efforts to regulate AI. Around the world, governments are working on how to control this rapidly evolving technology. So, for example, in the United States, a sector-specific approach prevails. AI is regulated differently in finance, healthcare, criminal justice, and national security. And this approach offers flexibility, but can lead to regularity gaps. At the same time, Canada and Australia have adopted national AI strategies focused on reasonable innovation. Canada's Directive on Automated Decision-Making 2019 is one of the first efforts to assess the impact of AI in public sector decision-making, including a mandatory algorithmic impact assessment. At the same time, China, meanwhile, is pioneering its own model, emphasizing data sovereignty and AI for national development. It rules on recommendation algorithm in digital platforms reflect a growing interest in controlling the flow of digital information. And of course, for legal professionals, this global regularity steps means we must remain informed about multiple compliance regimes. International clients may face overlapping or even conflicting legal obligations depending on where they opt or where the AI systems are developed, and that's one of the major problems that we might face. In litigation, AI is becoming an important tool for case strategy. Through predictive analytics, lawyers can assess likely outcomes based on jurisdiction, judge history, or claim type, and this enables lawyers to be more informed about decisions and whether to settle or to proceed to trial or appeal. At the same time, AI tools are also being used in jury selection by analyzing demographic data, social media activity, historical voting patterns. This helps lawyers identify potential bias or align jurors with their legal strategy, so it also raises ethical concerns. At the same time, in settlement negotiations, AI can stimulate outcomes based on similar past cases. It gives lawyers a stronger negotiating position and helps clients understand their option in quantitative terms. And most importantly, AI provides real-time insights. During a hearing or a trial, lawyers can use AI platforms to know more information about case law or identify weakness in opposing arguments, and this is more than a support, it's a strategic transformation. An important point to mention that AI should be seen not as a competitor, it is a collaborator. I will repeat again, AI should not be seen as a competitor, but as a collaborator. The key to success lies in interaction. AI handles the technical and repetitive, lawyers provide judgment and advocacy. And this strategy requires training. What do I mean by training? Lawyers, judges must learn how to use AI systems reasonably, understanding their capabilities, limitations, and ethical boundaries. The benefits are clear. Integrating AI into daily practice improves workflow, accelerates client services, and enhances accuracy. Clients benefit from quicker turnarounds and more detailed outcomes. Moreover, the lawyer-AI partnership ensures that legal advice remains both data-driven and human-centric. It's not about replacing lawyers. It is not about replacing judges by AI tools. It's about making them more effective in the digital world. Enhancing legal drafting with AI tools. In fact, legal drafting is another area where AI is making significant progress. Tools like cross intelligence use machine learning to review, correct, and also generate legal documents in real time. AI systems can identify, suggest alternative clauses, and ensure that contracts comply with specific laws or industry standards. For example, a system can flag if a force majeure clause is missing or outdated in a commercial contract, and that's one of the examples of using AI in drafting and in reviewing contracts. At the same time, AI can also generate templates based on prior agreements, saving valuable time for lawyers to review these agreements. For regulators and law firms alike, this means better compliance, fewer errors, and more time to save for the court and legal arguments. What is the role of continuous learning in AI for legal professionals? In fact, lawyers of the 21st century must be lifelong learners. Understanding status and case law is no longer enough. They must understand how an algorithm arrives at a conclusion and how data is classified and where risks lie. This calls for redefinition of legal competence, digital literacy, algorithmic accountability, and data ethics. All of these terms must be known by people working in the legal field. Ongoing training is vital, not only through law schools, but via bar associations, online certifications, and interdisciplinary workshops. Only through continuous education, and I'm repeating this point, I have repeated it several times, only through continuous education, we can ensure that legal professionals remain guardians of justice in an increasingly automated world. In fact, AI is now transforming dispute resolution itself. Platforms, and I'm giving you the example, platforms such as eBay's Resolution Center have resolved millions of disputes without going to court by using AI-assisted negotiation and mediation services. These systems analyze the case background, suggest resolutions, and facilitate agreements, all without requiring human intervention unless escalation is needed. And for example, a dispute over a defective online purchase can be resolved by AI suggesting a refund, replacement, or partial credit based on prior outcomes and user preferences. These tools are not only faster, they are cheaper, they are user-friendly, and in high-volume sectors like e-commerce, these services reduce litigation and improves court background. Now to the final slide. To conclude my presentation, we stand at a crossroads. AI offers the legal profession extraordinary opportunities, efficiency, accessibility, and new insights. But it also brings challenges, ethical uncertainty, algorithmic bias, and regularity division. The future of law is not AI versus humans, and I'm repeating it again. The future of law is not AI versus humans, it is about collaboration. A shared framework where machines assist but humans decide is the solution where innovation meets responsibility. And as legal professionals, we must hold AI not with fear, but with ethics and a firm commitment to justice. I finished my presentation. Thank you so much.
Thank you so much, Dr. Mohamed, for that wonderful presentation. You have covered, I would say, huge spectrum from practice to challenges from both sides, from legal profession as well as from AI, how AI could be used in several dimensions in the legal profession. I'm sure that the attendees would have enjoyed a lot, and